Good morning, everyone. We're going to get started. Thank you to all that called in, and then for everybody that's here with us live. I want to make one announcement. We are offering SHRM credit for today's presentation, so if you need human resources credits, please just send me an email and we'll get you that information. So today we're basically going to give sort of an overview of various topics in immigration. We're going to start out with an I-9 presentation, where we're going to talk about I-9 compliance practices, avoiding discrimination in the hiring process. We're then going to have our colleague Andrea talk a little bit about the non-immigrant visa options, the most common employment-based options. And then finally, Brendan will be talking about some of the most common green card processes. So I'm going to kick off with a little bit about the I-9. So in today's administration, we really need to have an awareness of I-9 requirements. We're living under an unprecedented culture of enforcement. So it's important for employers to have an understanding of not only how to complete the I-9 process, but navigating through the hiring process without engaging in nationality discrimination. Immigration Customs and Enforcement is the agency charged with administering the I-9 program. And they take a no-tolerance approach to I-9 completion and maintenance. And there's the potential for significant employer sanctions and penalties for really seemingly minor errors and noncompliance. So today we're going to talk about the I-9 hiring process, pitfalls, I-9 completion, and record keeping. So backing up a little bit, the I-9 came into existence under the Immigration Reform and Control Act in 1986. And it basically gave two competing mandates. So in exchange for a widespread amnesty program, the government wanted us to be able to limit future illegal immigration. So they implemented the I-9 requirement. And basically that requires employers to verify employment authorization for all employees. But at the same time, there's regulations in that act that basically prohibit an employer from engaging in employment discrimination based on nationality or citizenship. So it's sort of like a competing mandate. Employers they're charged with verifying somebody's employment authorization, but also they can't go too far in the process by discriminating against U.S. workers. So we're living under a new enforcement mentality, and we've seen very recent statistics on this that are a little bit alarming. So in 2018, there's been a 300 to 750% increase in worksite investigations, which include I-9 audits and worksite arrests. So in 2018, ICE reported 5,981 I-9 audits, up from only 1,691 in 2017. There were 6,848 worksite investigations in 2018 as well. There are significant penalties for violations of hiring practices and as well as completion of the I-9. So for unlawful employment, employers are liable for hiring unauthorized aliens, and that would range from $375 to $16,000 per violation. Failing to comply with I-9 requirements range $110 to $1,100 per violation. There's also criminal penalties for continuing practices of violations and knowing hire of illegal workers. Document fraud can range from $375 to $6,500 per document. And then unlawful discrimination in the hiring process, fines range from $375 to $16,000 per violation. And we've seen recent cases against very large organizations. Specifically, IBM had citizen-only preference requirements in advertising, and they were fined $44,000. You can't require somebody to be a U.S. citizen in order to hire them. Walmart had an $11 million fine for violation. So this is really where ICE is focused on. They're focused on businesses and removing the magnet of illegal immigration by going after employers. So the non-discrimination requirements, so this is all monitored by the Immigrant and Employee Rights section of the U.S. Department of Justice. So they're the organization charged with enforcing prohibitions on citizenship and nationality discrimination. So they set the policies on discrimination and actually prevent employers from asking certain questions on somebody's ability to work in the U.S. or immigration status. One of the big things is over-documentation. You want to be careful of asking an employee for specific documents. You're not allowed to do that. So one of the questions I get a lot is, can I ask to see an employee's green card if they say they have one? And the answer is no. An employer can never ask to see a specific document. The employer must accept documents if they appear to reasonably relate to the person and appear to be valid. The reality is you're not document experts, so if it looks legitimate, you're required to accept it. Obviously, the exception would be if the document presented doesn't appear to be valid, it's someone else's picture, or it's expired. Basically, if it's written in crayon or magic marker, you know that it's not legitimate. Now, the government does publish a guide that has pictures of the most common employment authorization documents. So it's called a Guide to Selected U.S. Travel and Identity Documents. So that's Form M396. So that's a good publication to get. It's free. You can get it. There's pictures of all of the worker documents that they would present for employment authorization. But whatever you do, consistency is key. You want to have a consistent process, and we'll talk a little bit more about that in a moment. So back to the actual hiring process. So again, U.S. workers are protected from employment discrimination based on national origin and citizenship, as well as a number of other grounds that are listed under Title VII. So you as an employer are required to determine whether someone's legally able to work in the U.S., but you have to be able to do that without the potential for employment discrimination. So one of the things I always say is look at the facts and not at the faces. You don't want to assume that someone is not a U.S. citizen or a U.S. worker just because they have an accent or because of their appearance. Now, there are a number of questions which you would think are common sense that you'd be able to ask to find out if someone's legally able to work. But there are a lot of traps in this, and there are a lot of questions that you think are okay that absolutely are not. I probably deal with this at least once a week with an employer, whether it's on their application form or online where they're asking certain questions about visa status, and it's really illegal. So you can't ask somebody if they're a U.S. citizen in the hiring process. That's discrimination. You cannot ask them what country they're from. You can't ask them if they have a green card. You cannot ask if they have a Social Security card. And you can't ask if you're not a U.S. citizen, what visa do you hold? Those are questions that would lead to allegations of employment discrimination. Now, there are ways to get the information you need to determine somebody's status, but you have to go through the back door to get those answers. So again, the Department of Justice is the agency that monitors all of this. They're the ones that carry out enforcement actions against employers that violate this. We've had employers that had online applications, and Department of Justice came across those applications online and saw questions that were what they considered illegal, and they had enforcement actions against them. So Department of Justice suggests certain language and questions to ask, and one of the questions early on that they developed was, do you have unrestricted work authorization for the U.S., i.e., are you a U.S. citizen or national, a U.S. permanent resident, an asylee, a refugee, or a temporary resident of the U.S.? Well, this is super confusing. And a lot of times the workers aren't going to understand what you're talking about if you ask that question. So we always recommend a much clearer version and a condensed version, which basically gives you the same information. So we ask, do you currently have unrestricted work authorization for the U.S., or would you require sponsorship for a working visa? I would add in now or in the future, and that basically covers everything. That'll answer the question or beg the question from the employee, I have unrestricted work authorization now and would not require sponsorship. So this means that they're probably a U.S. citizen, or maybe they have a green card. They're never going to need sponsorship from you. I have work authorization now, but would need sponsorship in the future. So maybe they have some sort of a temporary employment authorization document, or some form of limited employment authorization. Well, they may be able to start with you, but in the future they're going to need some sort of sponsorship. So that tells you they're not a U.S. citizen or a U.S. worker. And then finally, I would require sponsorship for a working visa. So this means that they're a foreign national for sure. They don't have the ability to work currently in the U.S. They need you to sponsor them for a visa. So that gives you pretty much all of the information you need to make that determination. Now, you are not required to sponsor anybody for a visa. That's not a requirement. If you find someone that is qualified, you like them, well, that's your decision. You just can't refuse to hire them for some unlawful discriminatory reason, but at the same time, you're not obligated to hire them or sponsor them for a visa. So just some general FAQs that come up. Can I complete an I-9 earlier than day one? Yes, but may not. But you can't complete an I-9 before a hiring decision is made. There has to be an offer, an acceptance, and then you do the I-9 form. You may complete it earlier if it's for a non-discriminatory business reason, and that you consistently apply it. So, for example, some employers will make the hiring decision. They would do the I-9 before, so after hiring decision, but they would do it before mandatory physical and drug tests. So you can have whatever policy you want that falls within those parameters. You just need to be consistent. You can't do it at one time for one employee and then another time for a different employee. May I accept receipts? So, there is an I-9 employer handbook that's available online. There's also a website, I-9 Central, that's administered by USCIS. Those are fantastic resources, and any question that you have is probably going to be in that document, and it's searchable. I use it all the time when questions arise, but they have great examples. There's a whole section on receipts as well. So you may accept a receipt for an identity document. So if someone loses an identity document and they need to replace it, you can accept a receipt for that. You cannot accept a receipt for an initial work document. So if someone's applying for a work visa, they haven't had one before and they just have a receipt notice. Well, that doesn't give them the ability to work, so you can't use it for an I-9. You can accept a receipt for a lost, stolen, or destroyed work document, however. So you would have a copy of the prior work authorization document and then a receipt showing that they filed to replace it. You may accept a receipt for renewal of certain employment authorization documents. So in November of 2016, there was an executive order that came out that basically agreed or allowed certain employment authorization documents to be extended, and then upon the receipt of that, they were given a 180-day extension on that until it was approved. So there's a list of those eligible forms of employment authorization on the USCIS website. So if it does qualify, then you can use a receipt to extend that on the I-9 form. You may accept a receipt for an OPT STEM extension. So if someone has a student visa, they have their 1 year of employment authorization, but then they're applying for the additional 24-month extension under the science, technology, and engineering provisions, then that would serve to automatically extend, and you can use the receipt for that.
Okay.
Yep.
The STEM extension can be up to 24 months?
It's the STEM extension is 24 months, right? And then you get 12 months of initial employment authorization. So you get 24 plus 12.
Gotcha.
That's the total amount of time someone can get on an F1 EAD. So another question that we get a lot is, should I keep copies of the documents that an employee gives me to fill out the I-9? And over time, that answer has changed because there were two competing schools of thought. If an I-9 is completed incorrectly and you have documents attached to it that shows that you did it incorrectly, well, you're handing that over on a silver platter to ICE in the event of an audit. The other school of thought is, yes, you should make a copy of everything that's given to you as a method of protection. Because if it turns out that maybe that document was illegal or fraudulent and you're getting an I-9 audit by ICE, they're going to say, well, this document is not legitimate, but you'll have a record saying, well, this is what they gave me. It looks real to me. I'm not a document expert, so we relied on it, so it can protect you in that way. But the current view is that you should make copies of the documents that are given. That is USCIS's current guidance, and it does make it easier to do your I-9 self-audits, because if there's a lot of turnover in the HR function or whoever's doing the I-9 form, you want to have a record of what was done in the past so that you, when you're doing your I-9 audits on your own, you can kind of see what they filled out before, what the documents were that were relied upon. So it just makes that easier, and I do recommend doing that. Now, if you, for years and years, if you've had a policy where you have not made copies, you can change that policy, but you want to be consistent going forward. So what I generally recommend is doing a memo to your file saying on such and such a date, the company made a decision to change its policy to now make copies of all supporting documents going forward from this date. And then just keep that on file so that there's a record that you thought about it. It's a policy change that's going to be applied consistently. Now, I will say that if you are an E-Verify employer, you are required to make copies of the documents that you are collecting. All right, some common pitfalls for employers. So some of the most common mistakes by employers during the process, the employer specifies which document the employee is to produce. So you tell them, this is the document I need. You can't do that. The employee looks at the instructions on the I-9. They present to you one of the documents from list A, B, or C. The employer sometimes may request too many documents. So again, for the I-9, if you have a list A document, you stop there. You don't fill out list B and C. Now, some employees get excited. They have all these documents they want to share with you, and they over-document. Well, just because they're giving them to you, you don't accept them. If they give you a document that qualifies for list A, you just take that document and you give back the other documents to the employee. You don't want to over-document. Employer fills out the I-9 form too early before a hiring decision is made. Employer fills out part 1 of the employee section, and then there may be a lack of employee signature. Employer fails to record expiration dates of work authorization documents so that they're not properly re-verified. Now, documentation errors alone won't give rise to a claim of employment discrimination per se, unless there's proof of your intent to discriminate, but you will be subject to fines and penalties for document errors. All right, some common problems. So Jose completed his I-9 and presented documents to me which appear to be valid, but I think he's illegal though. What should I do? Well, you should do nothing. You have complied with your obligations under the law, and you leave it at that. Now, the exception is if you have constructive knowledge from a reliable source that Jose is not authorized to work. For example, if he asks for visa sponsorship when he's already indicated he's a U.S. citizen, you know there's a red flag and you have to take action there. Maria told me that Jose is illegal and that his green card was fake. What should I do? Well, do you have constructive knowledge based on what Maria said? Is she reliable? Does she have a reason to know that? Do any other facts support her statement? So that's going to require some investigation on your part. You don't want to take rash action. You don't know what the relationship is between Maria and Jose, so you're going to have to investigate that. But if the documents appear valid and no other indicators exist, you do nothing. I'm hiring independent contractors. Do I have to do their I-9s? No, but the company providing the independent contractors should do I-9s for them. The company should provide assurances that the I-9s have been correctly completed. They're not your employees, so there's no obligation directly on your part to fill out an I-9. Can you outsource completion of I-9s? Yes, but even if you outsource, you retain all of the liability if those I-9s are filled out incorrectly. And again, a reminder, the employee must be physically present with the examiner of the document. So you can't do this by email or by Skype. It has to be an in-person meeting between the person preparing the I-9 for the employer and the employee. I am employing a worker to work outside the U.S. Do I need to complete an I-9? No, you do not. The I-9 requirements only touch those that are physically working in the U.S. That's a common question that we get because it doesn't make a whole lot of sense how you can have someone on your payroll as an employee, but there's no I-9. And that's because they're not physically working in the U.S. So it doesn't touch that situation. All right, some compliance best practices. So again, the formal ICE raid usually stems from an initial I-9 audit. So that's why this is so important. You should require every new employee to complete Section 1 on the first day of employment. Employee must provide verification documents from List A, B, or C by the end of the third workday, or you have to take them off the payroll. The employee may present any acceptable documents listed from List A, B, or C. You should not request any specific documents from the employee. Make copies of both sides of all documents that the employee presents to you. If the employee is not a U.S. citizen, you should note the visa expiration date and calendar it for 90 days so that you can timely re-verify and contact the employee for any updated visa authorization documents. You should keep I-9 forms separate from other personnel and payroll records. In the event of an audit, you don't want to give the government more documents than they need. It can compromise the employee's confidential information and privacy rights, so you don't want to have all the documents together. I normally like to keep a separate binder with all of your I-9s in them and just, keep separate the ones that need to be re-verified, like if they're not U.S. workers, so that you can keep those straight and then make sure that you're re-verifying. You should train your hiring managers on I-9 procedures regularly and document the training. This is especially important if there's turnover in the HR function or whoever's doing your I-9. You want to have evidence that there's frequent training just in case you get an audit and issues come up. You can at least help mitigate that by showing that you have a practice and policy of doing regular trainings, and this was sort of, just a one-off mistake that may have happened. All right, so finding answers, again, the Handbook for Employers is a great resource. It's Form M274. I've listed out a few of some of the issues that are common that come up. You can read those on your own. We're running a little short on time. We're going to move over to maintaining I-9 records. So just quickly, maintain I-9 copies for the statutory required period. They can be maintained electronically or in hard copy. So the rule is keep I-9s for all current employees. Doesn't matter how long they've been there, you keep that I-9 on file. Once the employment ends, however, keep I-9s at least 3 years from the date of initial employment or for 1 year after the employee leaves, whichever is later. You should promptly delete any I-9s that you can when possible after the statutory period is met. You don't want old I-9s hanging out for ICE to look at when they come knocking on your door. You should, again, maintain I-9 forms separately from your individual personnel records. It saves time if you do get an audit to be able to gather all that information. You get 3 days notice to produce I-9s in the event of an audit. It's easier to conduct your internal self-audits, and it's easier to organize for re-verification. You should create a reminder or tickler system for timely re-verification and record purging so that you don't miss any deadlines and that you're not having workers without work authorization after the expiration period. To amend, so if you're doing a self-audit and you need to make changes to mistakes made, you'd never backdate and never hide a change. You draw a line through any incorrect information, just initial and date the changes, and note the reason. A lot of times I like to include a memo and staple it to the I-9 just explaining what the error was and how you corrected it. Full disclosure is the key, and ICE appreciates that, and as long as you corrected it, even if it was done wrong originally, you're not going to be fined for it because you did catch it and complete it. If there are so many errors on that I-9 form that you can't even recognize it anymore, that's okay. You just complete a new I-9 and attach the old one to that I-9 just to show that you did take care of that. This slide talks about I-9 audits and the steps for that, and we're not going to cover that today, but that'll be there as a resource if you're interested in that. So that's all I have right now for the I-9s. At the end of this program, we're going to leave some time for questions. So if specific questions come up with anything we're talking about today, we're happy to answer those questions.
Okay, hi everybody. I'm Andrea, and I work with LJ at Harris Beach in the Syracuse office, and I am going to talk to you about non-immigrant visas, which can't possibly be covered in the time I'm given. So I'm going to largely focus a lot of my comments on the H-1B. Okay. So non-immigrant visas is everything that's not a permanent visa. So anything that's not a green card falls under the alphabet of non-immigrant visa types. The guiding principle for this is obviously they are temporary, so they are limited in duration, and upon entry, the individual, the type of A through Z non-immigrant visa they might be on is really dependent upon what is their purpose. That's what determines their non-immigrant visa category. So if their purpose is to come in as a visitor, they should claim the B visitor, B1, B2, visitor for tourism or visitor for business. If they're coming in as a student, they're F1, J1, or M1. So it's all, what's your purpose for entering the U.S.? And versus immigrant visa, which is the permanent visa, which I said. The I-94 arrival departure record that from most countries, they are issued and given a record. In Canada, they're not issued any sort of document for that. But that really determines their status. That's the controlling document for anyone who comes in under a non-immigrant visa category, because that's done at the border or the port of entry when they come in. So that's what their primary record through CBP, Border Patrol, and it's worth. I often tell clients, check that, check that record after you come in. You can check it online on CBP.gov and make sure it's correct. Because if an error is made there, you need to correct it. That in the expiration date, in the type of status you claimed, anything like that. And you can get it corrected while you're in the U.S., but you want to make sure it correctly reflects that. I put these questions here, what is meant by visa, what is status, what is visa status, because both in the real world and on media and even amongst immigration lawyers, those are often used interchangeably and often incorrectly, and so they've kind of lost some of their meaning, but there is a distinct difference. So the visa itself, the visa stamp, a lot of people say, if you're not from a visa waiver country, the visa is the physical stamp that goes in the passport that you may or, depending what country they're entering from and what type of status they're getting, they may or may not have or need. But that's really what a visa is. It's when they go to a consulate and get issued the stamp in their passport that reflects the status they're claiming. So what is status? Status is the A through Z. It's what type of non-immigrant visa you have, what type of visa status, and now they go together, right? Visa status are you claiming? So it's used sort of a lot interchangeably, but make sure if someone uses the term just visa or visa status, if it's an employee, that you're clarifying what it is they're referring to, because they might be talking about the stamp in your passport, and you might be talking about something else, like when their status ends. So just make sure that you're defining what you're talking about if you're having that conversation. So the most common non-immigrant visas that you might encounter as an employer or situations that come up that you might need to know about. Some of you may already know these, so go rather quickly. But the B1 visitor for business, B1, B2. So B2 is coming in as a tourist. If you are from a visa waiver country, you won't necessarily have that visa stamp in your passport. Like Canadians can just come in and out, present their passport. They don't get any sort of document to reflect that. But the important thing about that is people who come in as visitors, whether it's for business or tourism, need to understand the limits to what they're allowed to do if they come in on that status. Because the worst thing you can do is violate your non-immigrant visa status, and usually it comes up through engaging in activities that start to look like employment. And I always advise a very conservative definition because I think that's immigration's take on it, and advise clients to be careful how they even talk about what they're doing if they're asked at the border. Anything that would normally look like employment, if you show up regularly, if you obviously if you get paid for being at that place of employment or that organization, that's going to be deemed employment. Anything that someone else would regularly do and get paid for would be employment. So the B1 visitor for business is becoming more and more restrictive, and you have to be very careful. It's intended for business people who are coming in to attend a conference, maybe negotiate a contract, but they're not getting paid. They're not showing up to do regular work on a daily basis in an office. They're coming in for a specific purpose, business related. You have to be, I think that it's very strictly interpreted these days. You got to be careful about that. Okay. Employment visas that you may see in your workplace or commonly get inquiries about. The TN standing for Trade NAFTA, is a temporary work visa available only to Canadian, Mexican nationals that you can get admitted up to 3 years. The limits are you have to be entering in for the purpose of engaging in a profession that falls on this list, the NAFTA list. Some of them leave a little wiggle room. Most of them do not. It's very clearly defined, and they have to have those credentials for that job category. And you must have non-immigrant intent. You're just coming in under the TN status to do that employment for that term.
No extensions or anything like that.
You can extend, yes. You can extend in the U.S. You can go outside and reapply. But it's a completely fresh evaluation of that status when you apply to extend. It's not like a automatic extension kind of thing. It's treated as a new sort of fresh application. Canadians can apply for that at the border, at the port of entry, or at the airport through CBP. Mexicans have to go through a consulate with their application. Okay, H-1B professional workers. If a lot of our audience weren't via webinar, I'd ask for a show of hands of how many of you are familiar with this visa category. This is really the only basic professional work visa that we have available. There's another one, the O1, but that is really contingent upon showing that you are the top expert in your field and documenting that heavily. But as far as a professional work visa, this is it. This is the one you hear about in the news, and this is the one that's limited in number. You may have heard about that. It gets good and bad publicity out there. There was a 60 Minutes piece done a few years ago about the tech industry jobs, gobbling up all those visas. It's really important with the H-1B to understand, what do I mean when I say professional work visa? That means the job itself, not the person who's sitting in front of you asking if you'll sponsor them, but the job itself must require at least a bachelor's degree or higher in a certain degree or degree field, so a specialty occupation. There's a limit to these each year, 65,000, and then an additional 20 for if you've completed a U.S. master's program, so Institution of Higher Education in the United States master's program. Certain employers are exempt, and Brendan just wrote an excellent blog on our website about this. Who are these cap-exempt employers, and why is that important? It's because if you're subject to the cap, as most private employers are, the demand for these 85,000 is inching up every year and is really high. This year came in at a little over 200,000 applications that came in the first couple of days for those 85,000 available spots. So And that's gone up slightly. The last few years it's held steady right around 200,000 applications though. And employers file for that on April 1st to begin on October 1st, the government fiscal year. Okay, so I just said what happened this last cap season, which is, you know, if you work out the numbers, depending on whether you were going for the master's or the bachelor's cap, but in general, it gives you, you know, about a 30 to 40% chance of having that application even selected in the lottery. So USCIS treats these under a lottery system. They take them in. They don't look at the merits of the case or the contents. They assign a number. It is a random selection. And then if it's selected in the lottery, then they take a look at it and adjudicate it. What is H-1B registration? That is new legislation, new rule that just, well, it hasn't gone into effect yet, but will probably go into effect for next year's H-1B season, which is April 1st. This requires employers to register ahead of time. And again, the final rule on this and the timing of it hasn't come out, but most likely they will ask you to register with some basic employer information without submitting the full H-1B petition, so probably sometime in March. And then they do the random selection from those employers, and then you submit the H-1B petition. There's a lot of issues around this with the timing, with how that's going to work, with the timing of filing the petitions. We will wait and see if they have their registration program and the system up and running, but it's expected to be there for next year. Okay, so our students, I work a lot with, because of where I am in Syracuse, and there's so many universities around, and there's a burgeoning tech industry that really needs skilled STEM field, highly specialized computer and information technology engineers. Most of the students coming out of the universities in and around Central New York, at least, coming out of master's programs in those fields, almost all of them are foreign students, are on their F1 status, which means you have all these companies who need people with that specific skill set, and the people in the area are going to require some kind of, H-1B sponsorship. So I spend a lot of time talking to employers and talking to students about how to make that transition from student to a work visa status. And as LJ mentioned, F1 students get 1 year of work authorization as long as they're working in their field of study. STEM, extension, science, technology, engineering, math, and that the description of what falls under STEM has expanded in the last few years. So it might include jobs that you wouldn't necessarily think it would include, so it has expanded somewhat. They can get a 2-year STEM extension. So they can get up to 3 years of work authorization without the employer having to sponsor them, which is kind of a big deal because it cost savings to the employer as the individual can apply for it, the individual student through his or her school. But obviously before the end of that 3 years, and because of how the H-1B system works, usually even in the first year, you want to think about sponsoring that person for an H-1B. So if they're given 3 years after they graduate, and you know that there's this lottery system for H-1Bs, most employers who find the employee they want, who is a international student, get a few bites at the apple if they sponsor them for an H-1B visa the first year. So I'm in that situation. I know Brendan and LJ have seen that before too, with the companies that really want this person to stay and work for them. They, don't get selected the first year. They know they have 2 more years. Then they can apply again the following year. It's no guarantee, and people often ask, well, are my chances better the second time around? No. Government doesn't keep track of that, and it's just a whole new lottery each year. Important with J1s that differentiate from F1s that's worth mentioning. J1 is an exchange visitor. One category of J1 is students. So the F1 is just a student visa. You're coming in for a degree-seeking program, and you have a document called an I-20, and you come in to do those studies in that degree field. A J1 can be a J1 intern. It can be a J1 scholar, research scholar, a J1 professor, a J1, what's the word I'm looking for? It's a whole variety of physicians, summer camp counselors. So depending on which category of J1 you're in, there's different parameters to the program. But the important thing is whether or not that J1 is subject to a 2-year home residency requirement, meaning at the end of their defined J1 program, they either have to go back to their home country for 2 years or they have to have a waiver of that requirement. I don't even have enough time to talk about waivers depending on what category they're in. I don't know how I'm doing on time. I'm talking really fast. Okay. All right. But on the J1 document, which is the DS 2019, it does indicate whether or not they are subject. Sometimes that is wrong. So if you think it is wrong, or if the person who holds that J1 status tells you it is wrong, or tells you it's right and you think it's wrong, it's very important to get that resolved and know how it might apply to that individual. Because if they go forward under the mistaken assumption that they're not subject to that two-year requirement and go ahead and apply for something, and later it's determined they are subject to it, well, now you're caught out, and either that person is out of status by now, or at the very least it impacts everyone's plans, the employers, the employees, the person with their status, with their life, in an emergency way that you don't want to have to deal with. So if there's any question to whether they're subject to that 2-year home residency requirement for whatever category they're in, it's worthwhile, talking to a lawyer and having that looked at. And you can get what's called an advisory opinion as well from the Department of State. And there's a whole strategy to whether or not it's a good idea to ask for an advisory opinion or not. But that should be looked into. There are other non-immigrant visas. As I mentioned, there's a whole alphabet of them out there. In the work context, there's L1, intracompany transferees. So if you have a large company that has offices overseas and wants to transfer an employee from the overseas office into the U.S., they have to have worked there a year or more, and then it depends on what type of worker they are, whether or not it's for managers or specialized knowledge workers. E1 is for treaty traders. You have to be a company and an employee coming in from a country that falls under the treaty. O1s, extraordinary ability, depending on I think in our audience here we have several universities, representatives that work at universities. O1s is a good option for very highly qualified, very experienced workers who are in their specialized field. It's a lot more time-intensive work-wise, and the standard is very high to prove that. But it is an option if for some reason the H-1B is not available to you. P1s, again, a work visa status for performers, musicians in the arts, and R1s for religious workers. Okay, I'm going to stop there because we want to save room for questions because there's so much, and I'm not sure if I touched on what you all need to hear. So I'll give it over to Brendan now.
All right, thank you. So my name is Brendan Venter. I'm an immigration attorney here at Harris Beach, based out of our Albany office, and I'm going to be discussing the green card process, permanent residency. So just to kind of take a step back and orient you a little bit, Andrea has just discussed non-immigrant visas, such that those are temporary for a specific purpose, a specific event or engagement sometimes, and they're limited in what the individual can do based on which type of visa or status they have. A green card is otherwise known as permanent residency or an immigrant visa. So as compared to non-immigrant visas, the green card is an immigrant visa. It allows someone to come to the United States permanently to reside here. And with that, they get the ability to essentially stay as long as they want and do whatever they want for the most part in terms of their ability to work. So this slide here gives kind of a very high-level overview of the steps involved in a traditional green card process. Now, there's going to be some variation on this depending on a few factors, sometimes depending on the individual's background, sometimes depending on where the individual is located. So if you look on the left side here, we say most employment-based cases start here. So for a green card, it can really either be employment-based, where an employer is sponsoring an employee for permanent residency based on a job offer, or it can be family-based, where you have a U.S. citizen who wants to sponsor a spouse or a child or a parent for permanent residency based on their citizenship. So we're not going to discuss family-based a whole lot here today. Just know that that's kind of a whole other bucket of green cards that is available. We're going to focus on employment-based. So most employment-based cases do start with what's called a perm labor certification. I'm going to discuss that in a bit more detail later. Essentially, a very quick summary of the perm labor certification. It's a process an employer goes through with the Department of Labor to what they call test the labor market. So in order to sponsor a foreign worker for permanent residency, in most cases, an employer first has to show that they have tried to fill the position or they have tested the labor market to see if there are any qualified U.S. workers, meaning a U.S. citizen or a U.S. green card holder. If there are any qualified U.S. workers for that position. And if there are, if the employer wants to sponsor a foreign worker for a position where there's tons of U.S. workers who meet the qualifications and are ready, willing, and able to take that job, the rule is the employer cannot sponsor a foreign worker for permanent residency based on that position. So the employer has to show there are no minimally qualified U.S. workers for this position. That is a threshold requirement for a green card process. So a lot of people think that's required for an H-1B, for example. It's not. An H-1B, an employer can just sponsor someone for an H-1B visa, whether or not they're qualified U.S. workers. The green card is different, though. The employer does have to go through this labor certification to show that that's not the case. If they satisfy that, so let's say the employer does that perm labor certification, they sufficiently demonstrate there are no qualified U.S. workers for the position, then they can move on to the next step, which is now we're getting into U.S. Citizenship and Immigration Services world by filing a visa petition. So in the employment-based context, the visa petition is what's known as an I-140 petition. That's just the name of the form that gets submitted, an I-140. That petition, what the employer is saying is we would like to sponsor this particular foreign worker for permanent residency based on this specific job offer we've made to them. So they've completed the labor certification, showed that this position qualifies, essentially. Now with the visa petition stage, they're saying, okay, based on that labor certification, we now want to go ahead and sponsor this specific foreign worker for permanent residency. So that all that does is establish the employee's eligibility to later apply for a green card. The visa petition itself does nothing to the employee's status. So we have to go through this final step to actually change that employee's status to a permanent resident. And actually, I shouldn't say change status, because what the process is called is adjustment of status. So they are adjusting status if they're in the United States from a non-immigrant, so from a H-1B worker, from an O-1 worker. They are adjusting from that status to status as a permanent resident. Change of status is something different in the immigration world. That is going from one non-immigrant visa category to another. So if a student would change status from F1 to H1B, but they would adjust status from H1B to green card holder. So just to clarify that in case you hear those terms used. Now the two different options we have here, adjustment of status versus the alternative consular processing, that's typically governed by where the employee is located at the time they can apply for a green card. So in order to adjust status, they have to be in the United States in a non-immigrant status. So if they're here in an H-1B status, for example, they would file an application for adjustment of status. If they're outside the United States, obviously they're not here in a non-immigrant status, so they would go through what's called consular processing, where they would apply for an immigrant visa in their passport, again, similar to a non-immigrant visa. They would get an immigrant visa in their passport and then use that visa to enter the United States directly as a permanent resident. And then in either of these cases, at the end, the green card is issued. So they'll be issued a card, a permanent resident card. It actually is back to being partially green again. For years it wasn't actually green, which is funny. But it says permanent resident right on the top. They would hang on to that as proof of their status. And they're essentially a permanent resident forever until something happens. Maybe they get into trouble and that green card could become subject to revocation, or at some point down the road they may be interested in applying for U.S. citizenship. There's no requirement to apply for citizenship. Someone can remain a permanent resident for however long they want. So the green card structure we have set up in this country is limited in number. So kind of like the H-1Bs, which have that 85,000 cap, for green cards they are limited in number. So there's a certain number available each year, a certain number available in each different category, and a certain number available for each country. So it's kind of this complicated formula where all these things kind of get mixed together, and basically when there are too many people applying for green cards in one of those combinations in a particular category from a particular country, what can happen is these waiting backlogs can be created, and waiting periods can ensue, which I'll talk about in a little bit. Now I'll go back one slide here. So whenever an employee or an employer starts an employment-based green card process on behalf of an employee, the employee will get what's called a priority date. And the priority date is going to be the date that the process was started. So if it's a process that is subject to the Perm Labor Certification, the date that application is filed with the Department of Labor is that employee's priority date. If it's an employment-based case that is exempt from the Perm Labor Certification, which I'll mention a little later, then the first thing they file is going to be that I-140. They file that directly with USCIS, and the date that is filed would be the employee's priority date. The priority date determines essentially that employee's place in line for claiming one of these limited number of green cards. So when there is a backlog or a waiting period, green cards are made available to people who are waiting in priority date order. So those who started a process earlier get first priority when it comes to actually claiming one of the available green cards as they come up. Now, this issue of determining, well, what does my priority date mean? You know, if I have a priority date, how do I determine when I can actually apply for a green card? You have to look at what's called the Visa Bulletin, which is a document that's published each month by the U.S. Department of State. And if this is something you work with quite often in your position, you know, employees asking for green cards, what you can do is go onto the Department of State's website and you can actually subscribe to the Visa Bulletin, have it sent to you each month by email. So we all do that, obviously, so we get it as soon as it comes out. But if you're involved in the green card or permanent residency process for any of your employees, I would recommend you do that. And you can also tell the employees to do it as well, because more often than not, the employees are familiar with this. They've done their own research. and they kind of know generally what the visa bulletin is. So you can tell them, look, here's your priority date. You can subscribe to the visa bulletin. That way they can check each month as it comes out to see what's changed, and they may not be bothering you with questions all the time. So I'm going to help you interpret this a little bit so you can use this to have informed conversations with your employees about green card expectations and kind of how things are expected to proceed in their permanent residency process. So what I've excerpted here on this slide is one portion of the visa bulletin dealing with employment-based green cards, employment-based immigrant visas. On the left-hand column, you'll see the different employment categories. So they go from EB1 all the way down to EB5. EB just stands for employment-based. So you have EB1, which is the employment-based first preference. Employment-based second preference is EB2, and so on. These different categories are referring to different types of employment-based green cards. So EB1, again, I'll talk about a little bit later, but those are usually processes that are the most demanding, the highest level. Those are typically the ones that are exempt from the labor certification requirement. So those would be what's called, they have subcategories for just outstanding professor or researcher, which you'll see often in the higher ed context. Another one is aliens of extraordinary ability. So similar to the O1 non-immigrant visa, that's someone who's really at the top of his or her field, or multinational managers or executives. So akin to the L1 non-immigrant visa for individuals who may have been transferred to the U.S. from a company abroad in a managerial or executive level position. So EB2, EB3 are typically the categories that go through that perm labor certification, which we'll go through in detail on the next slides here. The difference between them is based on the requirements of the position. So if an employer sponsors an employee for a position or for permanent residency based on a job offer and the position requires a bachelor's degree and 1 year of experience, that's going to be an EB3, third preference category. EB2 is very similar. It's for positions that require either a master's degree or a bachelor's degree with at least 5 years of experience. So if you have a position where the minimum requirements are a bachelor's degree and 5 years of experience, that's going to be EB2, bumps it up a level from EB3, which is anything less than that. So if it's a bachelor's degree and 4 years of experience, that will be an EB3. If it's just a bachelor's degree, that will be an EB3. If it's an associate's degree, that will be an EB3. So EB3 is kind of the catch-all. We have some other categories here which are less common, so we don't really need to go into those now. But if you look at the visa bulletin, let's say you're sponsoring an employee for a position that requires a bachelor's degree and 5 years of experience. So that's going to be in the EB2 category. And let's say that employee was born in Spain. Well, we look on the top row, and there's no column for Spain. There are some specific countries listed, but Spain is not listed. So that means it's going to fall into this second column here for worldwide. Every other country that's not listed is in that worldwide category. So if you're sponsoring an employee who was born in Spain for a position that requires a bachelor's degree and 5 years of experience, we go down to EB2, we go over to worldwide, and there's a C there. That C means current. And what current means is essentially green cards are currently available. So there's no backlog, there's no waiting period. When you go through the perm labor certification and you get to the I-140 stage, because visas are currently available, you can actually do the I-140. I'm just going to go back to our initial slide. You can do that I-140 visa petition and the employee's adjustment of status at the same time. You can say, we're sponsoring this employee for permanent residency based on this job offer, and this employee is applying to adjust their status because there's a green card available. You can do those simultaneously because green cards are currently available. Now, if we switch it up, and let's say the employee was not born in Spain, but he or she was born in India, the situation gets much different. So in India, you'll see there's a date in the box for EB2 of April 19th, 2009. That is the cutoff date for green card availability. What this means is anyone who has a priority date earlier than April 19th of 2009, their spot in line is up, so they have a visa available to them. But if their priority date is after that date, they are still waiting. They're in the backlog, so they cannot finish the green card process yet. So an employer can do the I-140 petition and essentially communicate their intent to sponsor this person for permanent residency, but that employee cannot actually apply for a green card based on that sponsorship because their priority date is not current. So if you look at this April 19th, 2009 date, and you kind of think of what that means, it means an individual has to have a priority date earlier than April 19th, 2009. So they would have had to start a green card process before April 19th of 2009 in order to have a green card available to them right now in May or June of 2019. So they have probably been waiting at least 10 years to have a green card available to them. Now that's, one of the more extreme examples, but you'll see all different dates in here. A lot of these have waiting periods. So I mention this because it's important to stress to your employees who you have these discussions with that in many cases the green card process is not quick. That sometimes they think it's something that can be done right away. Even the process itself, to just do all the paperwork and go through all the steps, that takes in many cases a year or 2 years. Plus, if they're from, let's say, India, they have an additional period of time to wait for their number to become current. So I think managing expectations at the beginning of the process is very important. And in order for you to do that, you have to have some working knowledge of how the system works and how this visa bulletin works. So, this fluctuates every month. So they publish a new one each month, and it's all dependent on demand. So let's say if in the month of June, no one from India, shockingly, applied for a green card in EB2, well, then this priority date cutoff is probably going to advance a little bit. So it might move up to, let's say, July 19th, 2009, which will make a new set of people eligible to apply based on their priority date. Now, if more people than expected apply, the dates can also go back or retrogress. So, for example, in May of 2019, so we're showing June's visa bulletin here, but in May, for EB1 India, the cutoff date was something like February of 2017. And now all of a sudden in June, because they got a lot of demand in order to balance things out, the date went back almost 2 years or over 2 years to January of 2015. So this is always reacting to the number of people who are actually applying. You have to constantly monitor the visa bulletin each month and see how things are moving and kind of can sort of predict in a very broad sense or very estimated sense when your date might become current, but this can move any direction. It can stay the same, so it's really unpredictable month to month. Now, aside from the obvious of just being impatient, why are these waiting lists such a problem? Well, the problem is if an employer starts a green card process for an employee and they do a labor certification and they do an I-140 and then you have an employee from India who's waiting 10 years for their priority date to become current, well, just having that green card process started doesn't give that employee any ability to remain in the United States or to work here. So at the same time, they have to continuously maintain an underlying non-immigrant status if they want to remain in the United States. So if we go back to our example of an employee in EB2 India who has to wait 10 or more years for their priority date to come up, that individual is going to have to maintain, for example, H-1B status for the next 10 or 11 years before they can get their green card. So it's a burden on both employers and employees, Employers, have to monitor this and maintain all their employees who are on non-immigrant visas. It'll likely require several renewals of the H-1B, each of which comes at a cost. And the employees as well, it's some uncertainty for them because, every 3 years, let's say for an H-1B, they have to renew it. And you would hope, if they've been on an H-1B for many years, the renewal will just get approved without issue. But especially in today's climate, that's not always the case. Even renewals are getting subjected to increased scrutiny, even for people who have been in a particular status for many years. I had a client recently who had come to me because I was working with his spouse on a green card process. They were from India. He was on an H-1B. He had been on an H-1B for, I think, 12 or 13 years. So he was doing that through his employer. He had, I think, 4 H-1Bs, and just recently the employer filed their 5th H-1B petition for him. Nothing had changed about him. Nothing had changed about the petition. Well, all of a sudden, the 5th H-1B petition gets denied. So what does he do? He's left here without a status. He's been here in a valid status for 12, 13 years. And now all of a sudden, things are sort of kind of falling apart right when they're close to the end of the green card process. So you see those situations, and it requires a lot of work to just get to the point where you can finish a green card process.
Can you appeal that? Or it?
Yeah. I mean, any denial from USCIS essentially can be appealed, but it depends. It depends on what the issue was, and just if you do appeal, you have to do more than just say, well, the prior 4 H-1Bs were approved, unfortunately, so that they're no longer giving deference to any prior adjudication. They're looking at everything anew, so you have to reprove your case every single time, which is obviously just incredibly burdensome on both employers and employees. So as we said, you can't file the adjustment of status or consular process an immigrant visa until your priority date becomes current. So, this places an emphasis on planning ahead, kind of looking in the future and figuring out what is this going to require us to do for this particular employee. One of the other issues is when someone files for adjustment of status, they do get certain benefits of that. One of those is work authorization. So let's say you have an H-1B employee who you sponsor for permanent residency. They have a spouse who's here on an H-4 visa, which is a dependent of an H-1B. H-4s generally can't work, but if they're going through the green card process and they can file their adjustment of status, well, then that spouse can potentially get employment authorization through that. But if they can't file their adjustment of status and have to wait 10 years for their date to become current, they can't even get that work authorization. So there's certain benefits that people are deprived from because of these waiting periods. And another major issue is with children. So in that example, let's go back to the EB2 India employee who has a 10-year wait. Let's say when you start the green card process, they have a child who is 15 years old. Well, at that time, a 15-year-old child can get a green card as a dependent of the parent. As long as they're under 21. Well, if they're 15 when you start, and that person's going to have to wait 10 years, and you get to year 6 and the child turns 21, well, now that child has what they call aged out. The child can no longer process as dependent of the parent's green card process. So that child is essentially on his or her own. They'll have to get their own status, and also if they want permanent residency, either get it through their own employer or have their parent sponsor them through a family-based category, which is going to involve its own wait. So it creates all sorts of problems because of these waiting periods. So I'll start to speed up here a little bit. So the perm labor certification, as I said, is the first step in most employment-based green card processes. And as a reminder, what it is a test of the labor market to show that there are no minimally qualified, able, and willing U.S. workers that are available and interested in the position. So basically what this requires the employer to do to demonstrate that is the employer has to conduct a search. They have to go through certain recruitment and advertising steps that are set forth by law by the Department of Labor. the employer can't just say, well, we're always looking for this position and we never find anyone. You have to complete certain enumerated steps, which we'll talk about on the next slide. So these recruitment or advertising steps are pretty significant. There's several different things an employer has to do. As a minimum, an employer has to place what's called a job order with the state workforce agency. So in New York, it's through the New York State Department of Labor. You place a job order for 30 days with them. The employer also has to advertise the position in 2 Sunday newspapers, or it could be the same newspaper but 2 Sundays. And then there are an additional list of additional recruitment steps. There are 10 options available, and the employer must complete 3 of those. So those include things such as advertising on a commercial job search website, so like Monster.com, Indeed.com, advertising on the employer's website. You can place an ad in a different newspaper, just a weekday newspaper as opposed to the Sundays. You can advertise in campus placement offices, do a radio ad. So again, there's a list of 10 things. An employer must do 3 of them. And as the employer's advertising, they may or may not get individuals who apply for that position because the position is made publicly available. So you might get applicants. And the harsh thing about the perm labor certification process is it's in most cases, a minimally qualified standard. So let's say you're seeking to sponsor a foreign worker for a position that requires a bachelor's degree and 2 years of experience. So if you advertise those requirements, you get people who apply, and you get a U.S. worker to apply who has the required degree and they have the minimum experience. Well, if there's no other lawful basis to exclude that applicant, then technically you cannot proceed with sponsoring a foreign worker. And that is the case even if the foreign worker is more qualified than any U.S. workers you get. So if the minimum requirements are a bachelor's degree and 2 years of experience, but the foreign national employee you're sponsoring has a master's degree and 10 years of experience, and they're much more qualified than any of the applicants you get, you still, as long as if you get someone who applies who meets the minimum qualifications, it doesn't matter if the foreign national is more qualified, which is obviously not, it doesn't in any way reflect real-world employer practices. So I'm always reminding my clients when they don't get this, you have to just take a step back and realize we're in a different universe. We're playing by the Department of Labor's rules. This is not real-world recruitment or real-world employment practices. And unfortunately, it's not comparing whether the foreign national worker is more qualified than any minimally qualified U.S. workers. So the employer has to accept applications and evaluate them to determine if someone applies who meets those minimum qualifications. Now, for our folks who are here and listening who are with colleges and universities, there's a slightly different standard and process for faculty positions. So not staff, but for faculty, they are allowed to proceed under what's called special handling. So for faculty positions, the advertising requirements are reduced. They don't have to do 2 Sunday newspapers and pick 3 from the list of 10 alternatives. All the employer has to do is advertise in 1 national professional journal. And the other main difference is the standard is different. So whereas in a regular labor certification, it's that minimally qualified standard, for faculty, you're looking at, you can evaluate whether the foreign national is the most qualified. So if you get a bunch of people to apply and the individual you want to sponsor is more qualified than all of them, you can proceed with sponsoring that foreign national for permanent residency. So it's the most qualified standard as opposed to whether they're minimally qualified U.S. workers. So labor certification, as we mentioned, is the first step in an employment-based process, and if you pass that, then you can go on to the I-140 immigrant visa petition. Now, there are other green card options that, as I mentioned, are exempt from the labor certification requirement. So these are categories, as you can kind of see from their names and just thinking about what these would refer to, these are categories where essentially the U.S. government is saying, even if there are U.S. workers who meet the minimum qualifications for these positions, we don't really care. These categories of individuals are the ones who we want to come to the United States, even if there are U.S. workers who are qualified, because these people are extraordinary in some way. So if you have extraordinary ability, alien, again, someone who's at the top of his or her field, and that spans really any field from arts to business to science and technology. So it really is the flexible category, but it's very, very demanding. So you really have to show the individual is nationally and or internationally recognized in his or her field. They can't just be someone who's starting out. They have to have a reputation. They have to be well known and have to have done certain extraordinary things in their field to qualify. Outstanding researcher is similar, but more narrow. It's typically for teaching or research positions at institutions of higher education. There's some ability to use it for companies outside of that context, but it's most often used for colleges and universities. And again, it's very similar. It's a lot of times for faculty members who have a lot of publications, they've presented, they've done review work for journals in their field, they've won awards, so things like that, really showing what their credentials are. And these are very heavily documented. When we submit them, they're huge stacks of materials that we submit to prove the case. Multinational manager, I mentioned before, again, that's someone who was a manager or executive at a company abroad, and that company is seeking to transfer them to a related corporate entity in the U.S., so a subsidiary in the United States or a branch office, something like that. So those are not subject to the labor certification requirement. And then the last category that's exempt is what's called a national interest waiver, where the individual is doing work that is in the national interest of the United States. So maybe they're researching some sort of new cancer treatment, or maybe they, I've done them for individuals who are legal scholars who are working on some novel legal issue that's going to help with international relations with another country. So if they're doing something that's in the national interest of the United States, they can potentially qualify for a national interest waiver, and that waiver part refers to a waiver from the labor certification. So you don't have to go through the perm labor certification because we're not concerned with whether there are minimally qualified workers for these types of positions. So again, I'll have some slides here about outstanding researcher or professor, just for our colleagues here who are at colleges and universities. Gives you some information about that. There are certain criteria that they have to meet. Again, it's usually for tenured or tenured track teaching position or a comparable research position, most often at a university or other institution of higher education, but there's some limited exceptions for other types of employers who are engaged in a lot of research themselves. And then just to give you a flavor of what these require, I put the criteria here, the regulatory criteria for outstanding researchers. So you can kind of see what you have to demonstrate. You have to show it that they meet at least 2 of these, but that's just a threshold. If you satisfy 2, then what they're going to do is look at the whole case holistically and all the evidence, and USCIS is going to make a determination, is this someone who really qualifies for the high level of scrutiny that we apply to this. So it's very time intensive on the employee's behalf to gather all of these things, and then we would work then to put everything together in a package that gets submitted and hopefully demonstrates that they meet this high level. So that's kind of green cards in a nutshell, and we've exhausted our content here, but we're, as LJ and Andrea said, we're happy to take any questions from those present here or those who are on the line as well.
The conference has been unmuted.
Just unmuted it here, so if anyone has a question, feel free to speak up.
I have a question.
Sure.
On slide 6, you were talking about on the applications, do you currently have unrestricted work authorization? LJ, you were talking about that. Do we put all those categories on the application?
So the question was on one of the slides where we're talking about the magic question to ask in the interview process, whether you put all of those sub-questions under. You don't have to. Those are just the likely results of that question. But even so, I don't think there's a problem with doing that. I think you could list that on an application because it's not specifically asking that question. It's basically, asking, I guess, subcategories of that to get the answer. Anyone else via webinar that have any questions? Okay, if anything comes up later on and you think of a question, you can email any one of us at any time. We're happy to answer any follow-up questions. If you have specific examples or situations that you're facing, we're happy to answer those as well. So we thank everybody for participating. And again, if any HR folks need SHRM credit, you can email me, LJ, after the seminar, and we'll get you the information for that. But again, thank you all for participating. We want to thank CEG for sponsoring this as well. Have a good day.